Good morning. My
Good morning.
name's my name's Tim Thornton. I'm with Gray Duffy LLP in Encino, California. I'm talking today about additional insured endorsements, and let's get started. There is a chat feature in Zoom, so if you want to put questions in there, we can address those at the end of the presentation. So please feel free to do that. And I'm going to talk about additional insured endorsements. As I said, ISO, Insurance Services Office, provides about 35 additional insured endorsements, form endorsements, and many carriers have their own particular versions of these, which have their own original language or may just be adjusting or tweaking the ISO language. So additional insured status starts usually with additional insured status being requested in a contract between the parties, which requires both that the insurance be maintained and that the other party, the counterparty, be given additional insured status. The requirements are often paired with indemnity clauses and also sometimes with waivers of subrogation clauses. So you want to make sure to read all of those together. But I think that additional insured status has to be analyzed and stand on its own for the most part. And indemnity needs to be analyzed and stands on its own as well. The coverage we're talking about is liability coverage, not property coverage or first party coverage, in which case you'd be looking at a loss payee endorsement. So we're talking about additional insured or AI endorsements in liability policies. So some insurance requirements you'll see in the contracts between the insured and the other party. And let's use the construction contract example. Might say contractor shall be named as an additional insured under the subcontractor CGL policy for liability arising out of the performance of the work. It might further provide that coverage for the contractor as additional insured shall be provided by a policy provision or endorsement at least as broad as ISO CG 2010-1185. Of course, that's not available in the market anymore, and normally you need to have two separate endorsements to provide something roughly equivalent, one for the product's completed operations coverage and one for ongoing operations, which we're going to talk about later on. The contract provision might also require, have an excess or a primary and non-contributory provision, providing that the additional insurance is primary and that the contractor's insurance is excess and will not contribute. So that's another big issue we have out there. And often there'll be a dollar amount required, for example, $1 million or $5 million, depending on the size of the scope and scope of the work to be done. Sometimes there are other provisions they will require, for instance, contractual liability coverage, or they might specify products and completed operations coverage are required as part of the bargain for insurance. Some common additional insured situations we see a lot in practice are real property agreements or leases. The lease might require the tenant to name the owner as an additional insured under the tenant's policy for injury or damage arising out of the leased premises. On construction contracts, the subcontract, for example, might require the subcontractor to name the general contractor as an additional insured for injury or damage arising out of the subcontractor's work. On product vendor agreements with larger vendors, the contracts might require the manufacturer to name the vendor as an additional insured for injury or damage arising out of the products. And finally, on an equipment lease, the lessee might require the lessor, the lessor might be required to name the lessee may be required to name the lessor as an additional insured under its liability policy for injury or damage arising out of the use of the leased equipment. So what is the rationale or reason for this? What is the problem they're trying to solve? In case law, the courts state it's to guarantee the obligations under the indemnity provision very often, which I don't think quite gets to the heart of the matter and is not very correct. What really takes care of in guaranteeing the indemnity obligations is so-called contractual liability coverage. We're not going to talk about that very much today, but that is coverage that's provided under a CGL policy as an exception for insured contracts under an exclusion called the contractual liability exclusion. And among the definitions of insured contract is that part of any other contract related to your business where you, the named insured, assume the tort liability of another. So the additional insured endorsement does very much more than that. It can shift risk to an at-fault party even when an indemnity agreement might not be able to do so because of state law rules construing such indemnity agreements. For instance, limiting it to not allowing indemnity for active fault or sole active negligence. And it might shift, the additional insured endorsement might also apply even if an anti-indemnity statute would prohibit indemnification. So the coverage can be much broader there. So as an overview, the things that we want to look at going through an additional insured endorsement problem, or looking at the endorsement itself, is who's the additional insured, what is the subject matter or scope to which the endorsement applies, for instance, to the insured's work, to a project, to products, or to acts or omissions of the insured. What is the connection to the scope, for instance, arising out of the insured's work? Issues of fault, which are very controversial and troubling to everybody. And timing issues. The injury or damage has to occur during the policy period, but there are also issues about how this interacts with ongoing operations or products and completed operations. There's also the issue of the amount of coverage. There are conditions such as primary and non-contributory that we've already touched on. And there are legal restrictions sometimes, some states, which may prohibit full or even partial application of an additional insured endorsement in certain circumstances. So talking about who is an additional insured, the endorsements often have schedules to list the additional insured. Some do this by actually naming the additional insured. Some do this on a blanket basis, meaning they'll say either blanket basis or they'll say something like as required by contract or as required by written contract. They may do it per schedule on file with the company. So you need to figure out which one of those applies. If it's on a as required by contract, then you need to refer back to the contract between the named insured and the other party. If it's on a per schedule on file, you need to get a copy of that schedule. What about certificates of insurance? This is always a big problem we have. A certificate of insurance, let's say to take the example of the Accord certificate of insurance, states that it is only evidence of coverage and it does not alter or vary the terms of the insurance policy. Statutes in some states, such as California, that describe certificates of insurance state likewise that it does not alter the terms of the policy. So what if there is a certificate of insurance that states someone's named as an additional insured, but there's no additional insured endorsement and there's no requirement in the contract that they be added as an additional insured? This creates a lot of problems. Some states have pretty clear case law or statutes that say you don't consider the certificate of insurance. They might be evidence of some agreement, written or oral, between the additional insured and the named insured, and that will require some investigation to figure out what's going on there. And there might be issues about whether the insurance company is going to be bound by those, depending on case law in a given state and their knowledge of a particular certificate of insurance or their knowledge of that practice by their producers. Who is insured also gives us, who is an additional insured, also brings up this issue about privity. This came up in a case in New York called Gilbane TDX versus St. Paul. And the endorsement there provided that additional insureds include anyone with whom you agree to name as an additional insured. And the court interpreted that very specifically to mean just the counterparty with whom they were contracting. And the problem with that is the counterparty, which was a municipal authority, which was contracting with Gilbane TDX, their contract also required Gilbane TDX to name as additional insureds the construction manager, among others. And they were not covered by that additional insured language because it only specified the party with whom Gilbane TDX had contracted. So that was a problem, and ISO has addressed that with some endorsements now. There are endorsements that cover just the other person you are required to add as an additional insured with whom you're contracting, such as CG 2033 or more recently CG 2039, 1219, the new 2019 changes to the ISO CG AI endorsements. And then CG 2038 or now CG 2040, 1219 provides new additional insured status where required by written contract. And the 2040 form says any other person where required by written contract. So it's a matter of a very close parsing of that language that resulted in the Gilbane TDX versus St. Paul decision. So you want to look at the endorsement and see, does it say the additional insured is just the party with whom your named insured is contracting, or is it any other party they are required to name under the terms of the additional insured and endorsement and as provided in their contract with the other party. Subject matter or scope, it can relate to the insured's work, a project, a premises, a scheduled contract, your products, meaning the named insured's products, your completed operations, or acts or omissions of the insured. So it can also be in the construction context apply to, and products apply to, well, let's talk about the construction contracts, can apply to something like arising out of your work, which goes back to the old CG 2010-1185 endorsement, which has been construed to apply to ongoing and completed operations. But now that is split in more recent forms, so that ongoing operations is covered by CG 2010. So it stops as soon as the work is completed, or the work is completed enough to have been put to its intended use. And on the other side, on the completed operations, once the named insured is done with their work at the premises, or it's done with part of its work that could be put to its intended use, then the coverage is provided by a different endorsement. So you need to put both of these two together, for instance, the CG 2010 plus the CG 2037, to get coverage for both ongoing and completed operations. So completed operations in the new December 2019 ISO forms is covered under 2037, 2039, and 2040 forms. And the other issue we have, do that again, is connection or nexus, which I always pair with and consider with scope. So connection or nexus means some sort of causation or tie back to whatever that scope was. Does it just mean that the named insured is or the additional insured is vicariously liable for what the named insured did, the narrowest view? Does it mean that the additional insured is liable because of something the named insured in fact caused, some injury or damage that they caused? Does it mean proximate cause or legal cause? Or does it mean something else like minimal causation? And this has been, I'd say, the controversial issue for the last 20 years in terms of CGL endorsements. So a lot of the endorsements were originally written with arising out of language. So it would say arising out of your work, or arising out of your work for the additional insured, or arising out of your products or your completed operations, or arising out of the insured premises. Versus the more contemporary language would be caused in whole or in part by acts or omissions of you, the named insured, or anyone acting on your behalf, or your acts or omissions in the performance of your ongoing operations for the additional insured. So arising out of, what could possibly go wrong with that language? So let's say we have a clause, the additional insured is insured, but only with respect to liability arising out of your work. Historically, this was viewed as meaning caused by the work of the named insured, and in more restrictive jurisdictions and more restrictive interpretations, just to vicarious liability for what the named insured had done. But courts have increasingly adopted a minimal causation standard for language like this arising out of. And courts have applied this language even to cover something like the sole negligence of the additional insured. So for instance, let's consider a case. An employee of an electrical contractor is injured by falling through a roof hatch that was negligently maintained by the building owner. This is not part of the scope of the work of the electrical contractor. And the employee in this particular case had clocked out and was going to the airport to pick up his wife. So the question was, did the liability of the owner for the employee's injury arise out of the work that the electrical contractor was performing for the owner? And the court in California in the acceptance insurance versus Sayufi case said, yes, it did arise out of that, because arising out of does not require cause and fact or vicarious liability. It only requires minimal causation. And so what this minimal causation standard here signifies is that just by the fact of your employee being present at the work site or in connection with the work, even if the named insured did not cause it, did nothing to cause it, it wasn't even within their scope of work, just the presence of the employee was enough to satisfy the minimal causal standard. So after this, then you need to look at the endorsement and think about, did the insured's work cause the injury or damage, or was an employee or someone else involved with the insured, for instance, their subcontractors, employees, present at the site in connection with performing the work, and that minimal causation standard is enough to trigger coverage under this type of language. So that was a problem for a lot of carriers. They were not happy with that result, and ISO and even insureds were not unhappy if their coverage was being triggered by this type of minimal causation without any fault on their part, or with complete fault on the part of the additional insured. So in 2013, ISO started to change the language, and they added caused by language. And so, for instance, it would say the additional insured is an insured, but only with respect to tort liability caused in whole or in part by your acts or omissions in the performance of your ongoing operations for the additional insured, right? So we have this caused in whole or in part by language, and also this your acts or omissions, meaning the named insured's acts or omissions in the performance of the work. And that's an attempt to narrow down what's being picked up by these additional insured endorsements. So we consider scope in the contractors and owners type of endorsements. If the subcontractor's named is the named insured and the subcontractor causes the injury or damage, it's pretty straightforward, as we talked about. If they did not cause the injury or damage, what happens? Under the arising out of language, that doesn't very much matter. Under the caused in whole or in part by, it does matter. Now, one difficulty with this is it says caused in whole or in part by. And very often you don't know until the end of the case if it's caused in whole or in part by, so that if there's a potential, depending on the state you're looking at, if there's a potential that the named insured caused it in whole or in part, that might trigger a duty to defend, even though there might not eventually be a duty to indemnify. And that's still a problem that vexes a lot of carriers and named insureds who are wrestling with additional insureds coming under their coverage. And you might say, why do the named insureds carry? Why are they concerned? They're concerned because that what we call dilution of limits. If they might have $1 million of coverage, and that might be enough to take care of them. If that $1 million has to be shared, for instance, by the general contractor and the subcontractor, that might be a problem for the subcontractor if they don't have more coverage than that $1 million primary. So our other concerns here, we already talked about when an employee is present or a sub's employee is present. Is there additional insured coverage for the sole negligence of the additional insured? Under arising out of language, a lot of courts find that there is. Some modern forms will exclude it, sole negligence of the additional insured. I know that's in the ISO additional insured vendor endorsements, this exclusion for additional insured or sole negligence of the additional insured. And sometimes you don't know until the end of the case. For instance, in National Union versus Nationwide, there was sole negligence at the end of the case found by the jury on the part of the general contractor. So the general contractor was not entitled to indemnification under the subcontractor's policy. However, the court also found that until that determination was made at the end of the case, there was potential coverage, and therefore the subcontractor's carrier had to defend the general contractor. So that's that situation we have, that concern we have about whether, about potential for coverage and whether there has to be a duty to defend the additional insured. More contemporary ISO forms implement anti-indemnity, anti-insurance statute language with language such as coverage is permitted only to the extent permitted by law, or coverage is provided only to the extent permitted by law. So you find that in these, I think in the December 2013 and the December 2019 versions of the ISO additional insured endorsements. An example of a statute that prohibits this might be California Civil Code 2782.05 that prohibits indemnification by additional insurance to the extent the general contractor was at fault in a residential construction setting. Okay, so in that situation, California law prohibits indemnification. And you find these in, types of statutes in a number of jurisdictions. Most jurisdictions have anti-indemnity statutes, which prohibit indemnity in the case of active negligence on the part of the indemnity, or in the case of sole active negligence on the part of the indemnity. But that says nothing about insurance. And some states have oil field anti-indemnity statutes like Louisiana, Texas, and Oklahoma that have similar provisions with regard to oil field contracts. And more recently, legislatures have started to add this additional provision that prohibits insurance, where the indemnity would have been prohibited as well. So you need to check which law applies to the contract and analyze accordingly. Another issue about scope is that's provided in the more recent endorsements in 2013 and later is the stipulation that the additional insurance provided will not be broader than that required by contract. The problem that this is meant to address is that under the original additional insured endorsements would basically add the additional insured and not have any restrictions to if in fact the coverage required was restricted in the contract between, let's say, the subcontractor and the general contractor. And so this is meant to say that if the subcontractor is not required to provide a certain type of coverage, then the additional insured coverage is not going to provide that either. So, more contemporarily, we'll find that in CG 2010, 12, 19. Another issue where scope comes up is in the landlord-tenant situation, although it's a different type of issue. So very often the coverage is provided for arising out of the leased premises, or more recently caused by actual emissions of the named insured, in connection with the leased premises. So if a leasehold premises causes a trip and fall, that seems a pretty straightforward application that it's arising out of the leased premises. If a tenant plugs in too many devices into an electrical outlet and causes an electrical fire, or they're using a space heater because their office is cold in violation of local law or the terms of the lease, and that causes a fire of some sort, those seem to be very clearly related to and arise out of the leased premises. But what if the loss is off of the premises? For instance, what if an employee is walking from his or her parking space and falls on uneven payment on the landlord's premises, but not inside the actual leased premises? Or what if a business visitor, a copier repair person, is coming to repair the tenant's copy machine and falls on uneven payment on the landlord's premises, but not in the leased premises? The landlord will argue that that arises out of the leased premises, and the tenant may resist that, or the tenant's insurer may resist that. So we have a couple of cases here. Truck versus Amco from the California Court of Appeal just this year found there's just a situation where a car had struck a building and caused damage. The landlord had repaired it. Then the landlord leased those premises to a restaurant, and lo and behold, another car struck the restaurant and injured some patrons who sued for their injuries. The trial court found that the restaurant owner, who had no idea that this had happened, was not at fault, and they were dismissed from the case. And the landlord was left in the case. They were found to be at fault because they had knowledge about the prior, or potentially at fault, if, for instance, on a theory they should have installed bollards or something like that. And the court found that they were an additional insured under the tenant's business commercial general liability insurance policy, even though there was no fault on the part of the restaurant tenant. In Peerless versus Technology, which came out of the Second Circuit out of New York, a diner fell on a sidewalk outside of a restaurant. The restaurant owner was named as an additional insured on the restaurant's policy. Let me say that again. The restaurant named the owner, the premises owner, as an additional insured under its policy, but it excluded liability for injury not sustained on the leased premises. Nonetheless, the court found that this was tied to the use of the leased premises and that there was coverage. And this goes back to another New York Court of Appeal case, which found that there was coverage when a customer of a garage tripped on the sidewalk outside of the garage. Scope and Nexus also comes up in vendor endorsements. We have coverage for loss arising out of your product. What if the product catches fire and damages a home? Or what if the product breaks and cuts the user? Those are pretty straightforward applications to find that there is coverage that arises out of the product. But what if the injury is not caused by the product, but by negligent installation? For instance, what if a clothes dryer is installed improperly and causes a fire? Or what if a clothes washer is installed improperly and floods the customer home, damaging the floor and baseboards and walls? In those circumstances, then there's a fight at the first level between the installer and the vendor, the manufacturer, each pointing the finger at the other, that there's a defect in the product or that there's a negligence in the installation. At the insurance level, if there's coverage for the vendor of the product under the manufacturer's policy, and the question is, does it arise out of that if it was installation? And even if the installer was substantially at fault, there'd be a good question about whether that arose out of that work. There's a number of cases that would find that minimal causal connection there if you have a rising out of language. But if you have caused in whole or in part by language, then there might not be coverage, but again, there may be potential coverage if the customer is suing both on a theory that the product was defective and that it was defectively installed by the installer. We have a number of cases where deliverymen delivering cases of canned food to a restaurant and they slip and fall on ice or something slippery. Does this arise out of the product? There's a case out of Illinois called Dominic's Finer Food, which said, no, that did not arise out of the use of the product. So that's as far as people have tried to push it, but there's always a fight in terms of vendors' coverage. Then there are also timing issues. The policy only applies to injury or damage occurring during the policy period. And then there's a question about how this interacts, for instance, in the construction context with completed operations coverage and ongoing operations coverage. What if the ongoing operations were completed before the policy began? Or what if the policy ended, there's no contract in force, and yet there are completed operations exposures because a defect in the product or the work causes damage to some other property. So what is the effect of all that? Generally, the courts are looking to see whether there's injury or damage during the policy period. Even if the contracts expired, the insured at one time was required to provide that coverage. And that was the holding in a California Court of Appeal case called Pardee Construction, where the additional insured contracts were long, the additional insured's coverage was placed long after the policies had expired, but during a time when there was alleged defects in the work causing damage, property damage. So in that case, the court found that the coverage was provided by those additional insured endorsements. There were also limitations often found in the blanket language requiring that the contracts be executed or signed before the injury or damage takes place. That raises questions about what does executed or signed mean, particularly in our day and age where we have a lot of back and forth with emails, exchanges of requests for proposals and pricing plans. And additionally, I've recently had a case involving the issue about the word executed. What does that mean? Does that mean signed, or does that mean performed? Because in the law, most lawyers, we talk about executed and executory contracts. An executed contract just means someone has performed their part of the contract. So that's something to be cognizant of. In most of the current ISO endorsements, the December 2019 forms, it just requires a written contract, and it doesn't use the language of executed or signed before the injury or damage takes place. Also, there are restrictions sometimes. For instance, there's no coverage for injury or damage occurring after the lease ends or after the equipment rental or equipment lease ends. So you want to watch for those as well. There's some new developments in terms of the ongoing and completed operations coverage. That bright line between completed operations and ongoing operations under the CGL form, which I like to be a bright line, but the courts have not always agreed with that. So that sometimes in a couple of recent cases, Pulte Home versus American Safety and Macmillan Management versus Financial Pacific, the court found that if there was some indication that some of the damage was ongoing during the completed operations, even though the policies did not, or during the ongoing operations. In other words, the defect begins to manifest during and cause damage during the ongoing operations. And the policy does not provide completed operations coverage. Nonetheless, the courts have held, at least in those two cases, that since some of the damage was ongoing during the ongoing operations phase, the policy was triggered, therefore it has to respond and provide a defense to the additional insured for the claim, which then is hard to divide between the ongoing and completed operations parts of it. Then we have issues about amount of coverage. Normally it's limited to the amount of the policy, unless we have some other language in there, but now we have language in there, probably since about 2013. For example, this comes from the 2037-1219 for ISO additional insured endorsement. It says the most we will pay on behalf of the additional insured is the amount of insurance required by the contractor agreement or available under the applicable limit of insurance, whichever is less. So that's pretty clear. The issue that was addressing was a situation where there's coverage was for an amount greater than that was required by the contract. For instance, the named insured might be required to provide $500,000 in insurance. The insurance policy might provide $1 million limit, and unless there's some language like this to restrict it, the $1 million limit is going to apply to the additional insured. So insurers and insureds who are providing the additional insured coverage wanted to tailor this, and this is how it's been done in the ISO forms. Another problem we have here is overlying excess policies being exposed to additional insureds, even though that was not within the understanding or intent of the contracting parties. Very often the additional insured, the excess policy or umbrella policy will say anyone who's an insured under the primary policy is also an insured under this policy. And for instance, in the industrial chemical versus North River case, the policy insured a manufacturer of chemicals. The manufacturer and a vendor were sued when those chemicals caught fire during a tank cleaning and burned and killed 2 workers. And the contract between the distributor and the manufacturer only required $1 million in coverage. So they had the $1 million primary, but with North River, there was also a $10 million excess policy for the manufacturer. And the court found that that applied to the additional insured as well, because there is no language to restrict that. Another case where that happened is in California, Vitten Construction versus Pacific Insurance, where an injured worker was badly injured falling through an opening in a roof deck. And the named insured was not at all at fault. It was not their responsibility, but nonetheless, there was a rising out of language. They had to provide the additional insurance. And that extended up to the Pacific Insurance, the excess insurer of the additional insured, of the named insured. And they were required to indemnify the additional insured under their policy as well. So you're going to watch that in excess policies to the extent they provide coverage, and follow form to the provide coverage for anyone who's insured under the named the primary policy, and whether that's just as required by the policy and only to that limit. Okay. Then conditions, we've talked about primary and non-contributory as being a term that's often found in the contract between the named insured and the additional insured. The additional insurer has, even though they might provide coverage, theoretically has a right to sue the direct insurer. The named insurer's insurer can sue the additional insurer's insurer for contribution because they both cover the same risk on an equal basis, on a primary basis. Therefore, they should split it 50-50 or in some other way. And that would apply to defense and indemnity. Now, the parties seeking additional insured coverage were not satisfied with this result, so they very often require that the additional insurance be primary and non-contributory, meaning that the subcontractor's policy, as an example, is going to pay its full limit before the additional insurance policy pays anything. And that way, the additional insurance policy also can avoid a duty to defend. So that's what the primary and non-contributory language means. Now, the standard, what we have in the CGL endorsement, or the ISO additional insured endorsements, is a form CG 21 or 2001, which says that coverage is primary and contributory only if you've agreed to do so in writing. Okay, so that is provided by way of that endorsement if the named insured wants that, because they don't want to provide primary and non-contributory unless required by their contract. The standard CGL now has dealt with this issue as well, right? So the standard CGL says the policy is primary unless otherwise provided. Then it says that it's excess in a certain number of circumstances. And one of those is it's excess where the named insured has been added as an additional insured and under another policy by endorsement or otherwise. And so it says any primary insurance for which you've been added as an additional insured. And so this is an attempt in the ISO policies to wrestle with this issue as well, to make one policy primary and one policy excess. There are legal restrictions on additional insured coverage, as we discussed above. Some states are now enacting what I call anti-insurance statutes to go along with the anti-indemnity statutes. We talked about the example from California about residential construction and basically limiting the additional insurance basically to the percentage of fault. And that is found in a number of other statutes as well. The very first state to do this, I think, was Oregon. So these statutes will provide additional insurance, but they will limit it to the amount that is equal to the fault of the additional insured. We talked about this 2782.05 of the California Civil Code, which states that provisions contained in, collateral to, or affecting any construction contract that require a subcontractor to insure, indemnify, including the cost to defend a general contractor, are void and unenforceable to the extent the claims arise out of the active negligence or willful misconduct of the general contractor. So that's basically putting a comparative fault limitation into the insurance by virtue of this statute. In California, this is effective on and after January 1, 2013, so contemporary construction. Lastly, I was just going to quickly run through additional insured endorsements, how they've evolved in the coverage for your work or ongoing operation situation, just to see how this works out over the course of time. So we have CG 2010-1185 arising out of your work, coverage arising out of your work. Then in the 1993, they changed it to provide coverage for your ongoing operations arising out of your work or arising out of your ongoing operations in CG 2010-1093 and 2010-1001, the 2001 form and the 1993 form. Then in 2004, they limited to caused in whole or in part by your acts or omissions in the performance of your ongoing operations, trying to pull it back from that arising out of expansive minimal causation determination. And then in 2004, they add this language we've been talking about, but only to the extent permitted by law, not for broader coverage than is required by the contract between the named insured and the additional insured, and not for greater limits than is required by the additional insured contract, or not for greater than the amount required or the limits of the policy, whichever is less. We see that in the 2013 forms. On the completed operations side, we have coverage for your work arising out of your work at the designated location, included within the completed operations hazard under the 2001 version of 2037. And then in 2004 and 2013, we get the caused in whole or in part by your work at the designated location within the completed operations hazard. So again, trying to address that causation issue. And as well, you see they split it up so that you can pick one form on the completed operations side, and the insured can pick another form on the ongoing operations side. So some takeaways from all of this, or from my experience in dealing with this. The first is to get the subject contract. If it's get the construction subcontract, the lease, or the vendor agreement. Often they won't give it to you, you want to get it. Sometimes they'll give you just the hold harmless or the additional insured language. You want to get the whole agreement if you can. You at least want to get the hold harmless, the additional insurance, and any choice of law provision that's in there. If there's any schedules, you may want to get or appendices, you may want to get those. For instance, a lot of contracts will have we want the insurance provided in Appendix A. Then Appendix A is a 7 to 9 page form. You want to get that to see what exactly is required. And you do want to get the choice of law. You want to understand the choice of law because that can affect what law applies to the indemnity and maybe what law applies to the additional insurance. You also want to see in the contract there may be more specific indemnification provisions in certain circumstances with regard to certain provisions of the contract. So you want to see that. You also want to see what the responsibilities of the parties are under the contract. That doesn't always help. For instance, in that Vitten versus Pacific case we talked about, the insurer's obligation was just to cut holes in the roof deck and put wood around it. And it was the general contractor's responsibility to cover those openings or to put a railing around them. And the general contractor failed to do that. Nonetheless, the court found that the additional insurance coverage provided coverage to that additional insured for something that was clearly their sole fault. A few other takeaways: if the insured or party claiming to be an insured just send a certificate of insurance, get more. See if there is an endorsement naming that party, or see if there's some sort of blanket endorsement. The new 2019 forms from ISO include some endorsements with the blanket language already built in to the endorsement itself. You want to get the AI endorsement that names the party, if they have it, If there's a schedule on file that lists additional insurers, then you want to get that, or some representation from the AI carrier that the party is on the schedule. You want to consider the indemnity agreement also. The additional insured endorsement may apply even if the indemnity agreement does not, or the indemnity agreement may apply to and cover things that the additional insurance does not apply to. So you always have to look at both sides of that. The consent, the additional insurance may have consent to pay or incur obligation type of language that may not apply to the indemnity agreement. There might be payment of attorney's fees covered under the indemnity agreement that's not covered under the insurance. And in terms of amount, normally the indemnity is not limited, whereas insurance is limited to the amount of the insurance. Sometimes the parties will stipulate or provide that the coverage provided, or that the indemnity will not exceed the amount of the coverage provided, so you want to look for that language as well. Finally, you may have situations where the insured fails to procure coverage. This is a breach of contract. Technically, it's not covered under the insurance policy because it's a breach of a contract obligation to buy insurance. It's not a failure to indemnify someone. So you want to take a look and be aware of that issue, and whether you want to assert it or not, and whether it creates a conflict between the carrier and the insured. There's my contact information. So let me find and see if we have any questions in the chat. I gotta find that now. So let me stop my screen sharing. We will have the slide deck, the PowerPoint presentation will be sent to all of you by email as you registered, and you'll have all this information available for you. There is an article about additional insured endorsements I wrote about a year ago that's also on the firm's website that you might find useful. And so let me stop sharing my screen here and see if I can find out about if we have any questions. Okay, so here's chat. Does an AI, so the one question I have is, oh, it's a private one, okay. Whether an AI, an additional insured, gets indemnity before liability is proven. So I'll just discuss it as a general matter. Normally they do not get indemnity before it's proven, but if there is a settlement and the settlement can be enforced against the parties, that may do it. But no, normally you got to wait for the actual determination of fault or responsibility. And again, that's something that can vary by state. States have different rules about the extent to which carriers are, or to which the insurers are bound by the consent, no voluntary payments or consent to settle or incur obligations provisions, which normally restrict the insured going to settle. And then you also have the issue about if you deny defense. If a carrier denies defense to the insured, then the insured is excused from complying with any obligations under the policy, subject only to the proving coverage, because the denial of a duty to defend is a breach of the policy. So that's a general answer to that question generally, and I will follow up with the individual later on. Any other questions? If not, thank you very much for your attention. I appreciate your attention to everything I've had to say. If you got any questions, you got my contact information on the last slide in the slide deck. Please feel free to email me. Again, I thank you for your attention, and I'm going to end the meeting now. There's also, I believe, a recording being made that will be posted on the firm's website after the appropriate people edit that down. Okay, well, thank you very much. Have a great day. Stay safe.